All right, welcome everybody to our session, our 1:30 session today. We appreciate everyone joining us, coming back in, and I'm sure hopefully we'll have a few more join us as we go, some late lunchers out there. So I'm Thomas Haire, the Chief Content Officer of the PDMI, and I'm thrilled to welcome you to today's session, assessing the FTC's priorities, with a great group of members of our Government Affairs Council here to talk to you about what's going on when it comes to regulation, the current status of where the FTC is headed, which seems rather aggressive according to all of our pre-calls, and so forth. So first off, we want to thank our education sponsor, and that is Mojo. And here's a brief message from Greg at Mojo.
Before the session begins, I'd just like to say that Mojo is a very proud sponsor of the education series. We hope you go to every session, ask lots of questions, and learn new things. Enjoy your day. We'll see you soon.
Thank you, Greg. And I've always been a fan of Greg's background that he uses for Zooms with those pretty cool movie posters. I'd like to welcome this group. I'm going to introduce you, the three of them in alpha order. Ed Glynn, who's of course in the center next to me, is of counsel at Locke. He offers his clients decades of experience in advising leading consumer products and services, pharmaceutical and dietary supplements, and advertising and marketing companies on federal and state regulatory matters, government investigations, and litigation. He provides strategic business counseling involving consumer protection, marketing, and trade regulation issues. As a former senior official in the Federal Trade Commission, his practice includes advising clients facing federal and state regulatory investigations, including the FTC investigations, and much, much more. Ed, thanks for joining us. To the far left of me is Leonard Gordon. Len is the co-chair of Venable's Advertising and Marketing Group, a skilled litigator who leverages his significant experience for working for the FTC to help protect his clients' interests and guide their business activity. He regularly represents companies and individuals in investigations and litigation with the FTC, state attorneys general, the Department of Justice, and the Consumer Financial Protection Bureau. He also represents clients in business-to-business and class action litigation involving both consumer protection and antitrust issues. Thank you for joining us, Len, as always.
Thank you, Tom.
And last but not least, right next to me is Randal Shaheen. Randy has more than 30 years of experience as an advertising attorney. He's a member of BakerHostetler's advertising, marketing, and digital media team and represents clients before a variety of regulatory agencies, including the FTC, CFPB, NAD, and more. His background facilitates practical insight. He has a significant history with matters related to privacy and data security, marketing to children, green claims, dietary supplements, claims of weight loss and health and performance, and others. We thank you all for joining us here. Thank you, Randy, for being here today on kind of short notice. Randy replaced Linda, who couldn't make it, but we're happy to have you here. So,
thanks, Tom.
Let's get started. I'm going to start, actually, I'm going to go to Len first, I think, on this first question about Lina Khan, the new FTC chairwoman. She's known as an aggressive proponent of big tech antitrust measures and has taken a fairly hardline stance across the board when it comes to her new role. Where do you see her priorities landing in the coming years, and how will they affect the performance and direct-to-consumer marketing industry?
Thanks, Tom. Good question. I think personalities matter. Lina Khan is 32 years old. She has never worked in the private sector. She's an academic, and she was an attorney advisor to FTC Commissioner Chopra. She became famous because she wrote a law review article, The Amazon Paradox, talking about the antitrust case against Amazon and other big tech companies, and that is clearly her focus. But what's interesting is she wants to attack big tech and others by sort of melding the two missions of the Federal Trade Commission, the consumer protection mission and the competition mission, and look at things more holistically. She sent a memo to the FTC staff, I think it was last week. We wrote about it, Alex wrote about it, and she clearly wants to use FTC consumer protection lawyers to look at antitrust antitrust merger filings to see if they can find cases. She may want to raid the Bureau of Consumer Protection to try and bring antitrust cases, but she also is clearly going to be very aggressive on consumer protection issues. I think part of the issue for her is she has very much centralized things. She has barred FTC staff from going out and speaking at events like this, which is really remarkable. Commissioner Chopra, who was clearly her mentor, refused to meet with industry, and not clear whether she and her folks are going to meet with industry on self-regulatory issues, on policy issues, or not. We'll see. But I mean, very, very sort of concentrated, somewhat insular. What her priorities are going to be. She's going to look at private equity. I mean, in her manifesto talks about that. She's very focused on protecting marginalized communities, both in the antitrust and in the consumer protection side. She's concerned about dominant intermediaries. So that might mean platforms. That might mean, we're not quite sure exactly what that means, but that's one of the sort of buzzwords she throws around. I think it may mean that she's going to look at payment processors again. You may see a redux of Operation Choke Point. I think all consumer protection law enforcers are challenged by sort of feeling like they're playing whack-a-mole. So I think that's something they'll do. She's talked about unfair contracts to consumers and to small businesses. So that could be franchises, that could be click wrap, that could be all the types of things you have to agree to when you purchase something online. And one of the things that's clear, both on the antitrust and in the consumer protection side, is she intends to use uncertainty as a law enforcement tool. She's taken away some antitrust policy statements, and there's a lot of talk about sort of dark patterns. It's something we can talk about more later, but no one knows exactly what that means. But there's a lot of uncertainty about where the lines are, and I think it's her hope that that uncertainty will chill behavior that she doesn't like, that may or may not be illegal, but it's certainly disfavored in, at least in her mind. The right to repair, another issue that crosses the line between consumer protection and antitrust. If you sell somebody something, do they have the right to get it repaired at an independent repair shop, or do they have to go to the manufacturer's approved representative? And I'll come back to dark patterns later, but I mean that at least in my view are some of her priorities. We'll talk about rulemaking. There are so many things she has indicated she wants to do. How they're going to do it and in what order they're going to do it, I think, is going to be one of the great mysteries that we'll have to solve.
Ed, what were your thoughts?
Yeah, I think Len hit on the crucial fact, which is uncertainty as to what her priorities are and how she intends to go after them. She has given a number of speeches or statements after commission meetings. And those of us in the business of advising firms before the commission have sort of gone through almost like Chairman Mao's red book, sort of analyzing what various things could mean. She clearly cares a lot more about antitrust than she does about consumer protection. That's my take anyway. But I think she sees consumer protection as a treasure trove of work hours that can be transferred into antitrust. And one of the ways that she's going to do that is by envisioning a merging of the antitrust and consumer protection functions of the FTC, which for as long as I can recall are certainly related. And people have been talking about, the relationship between the two. But the two bureaus have had a very sort of different approach to life and to procedures and that kind of thing. And she really does want to, I think, see what she can do with the Bureau of Consumer Protection to advance some of her antitrust priorities. And I guess the last thing I would say, and this is sort of unusual, and I think Glenn sort of hinted at it. There's been a consensus, I think, on not just the antitrust, but the general Federal Trade Commission side of the ledger since, I don't know, maybe the mid-'80s, that the purpose of the agency was to enhance the welfare of the consumer. Whether that's in keeping prices low on the antitrust side or enhancing consumer choice and the clarity of purchasing options and that sort of thing on the consumer protection side. And she is saying, wait a minute, not just consumers, we are interested in enhancing the rights of workers, competitors, Whereas under the traditional view, it's been the purpose of the agency is to protect, for example, competition, not competitors. That is not Chair Khan's view as far as it's been articulated. So I think it's very much at this point up in the air as to where she is going to go. But it's had an effect, and we can get into discussions of the effect it's had of the on the working attorneys at the FTC, many of whom the three of us know quite well. And I think that there are some ulcers that are beginning to be generated by the members of the staff.
Randy?
Yeah, I mean, I would say if there's a glimmer of hope amongst this doom and gloom, which I largely agree with, I think it's, at least for the folks kind of, in this room and on this floor today, in terms of what the focus is going to be, I think, she's very much focused on these large tech companies. It's going to take a lot of foot soldiers to wage that war. And I also think in past commissions, there's often this sense that the Fortune 500 companies are generally kind of well-meaning. They have in-house counsel to review things. And so more focus on going after smaller companies. But I think what I'm hearing is the attitude now is more all business is bad, doesn't matter, right? And so you're going to get a lot more bang for your buck in terms of saving consumers if you're going after the Procter & Gambles of the world, because they're out there doing a lot more marketing, a lot more harm under that kind of scenario. So it's not to say that smaller companies should do whatever the heck they want, that they're going to have some sort of immunity, but I do think we're going to see a lot more resources, a lot more focus on bigger brands, bigger companies.
Yeah, I think that she hinted at that last week, if I'm recalling in a statement. There was a story that I read where the idea now is that she is going to go after those bigger players, and that perhaps the smaller players are going to be not necessarily safer, but less targeted. Any thoughts from you, Len or Ed, on that idea?
I think if you're a smaller player and you do get targeted, you should not expect that Chair Khan will go easy on you. I think that would be a really foolish thing to think. I suppose the speeding analogy. When you talk to clients, you go, well, everybody's doing this, and you give that expression to the FTC. They say that's like telling the cop everybody's speeding. But if there's a tractor trailer speeding and you're speeding, maybe the cop pulls over the tractor trailer. It's a little bit of a mystery. I mean, Sam Levine, who she has appointed to be the director of the Bureau of Consumer Protection, has said that he thinks the FTC has gone too easy on companies. Now, maybe that's big companies, but I assume that's small companies too. Now, as we'll talk about some of the tools the FTC has used, maybe a little impaired right now. But I don't think anybody should leave this thinking, well, I can do whatever I want and don't have to worry about it, because the states are still out there as well, and the CFPB is out there, and I'm sure under new Chairman Chopra, they will take a very expansive view of their portfolio.
Makes sense.
Yeah. Now, just to say quickly, if you look at why the FTC starts consumer protection investigations, in general, it's unrelated to the size of the company. I mean, if you're on 60 Minutes and they're talking about you ripping off the consumer, you can be fairly well confident that you're going to get a letter from 6th in Pennsylvania or some civil investigative demand. Similarly, referrals from the Better Business Bureau, from sort of a series in the New York Times or the Washington Post. Anything that casts a spotlight on the company as an exploiter of people is, and whether that's a large company or a medium-sized company that's big enough to rip off a lot of folks, is the kind of thing that is going to attract the FTC in interest.
Right. Going back to something both Len and you mentioned, Ed, I'm going to go to you first on this. FTC staff. The ones who are actually out there directly handling cases, the word is that they're becoming more and more difficult to work with, that it's just really ugly in working with them. Can you talk a little bit about what your perspective is and why do you think that's happening?
Well, I've seen it recently, but also I wouldn't say that a lot of these folks are close friends, but they are associates in the sense that they're adversaries that we've dealt with for a long time. And in many cases, they're fellow Washingtonians that you see at basketball games or something. I mean, you know them. You may not be terribly close. But I do have the sense, and I think all of us up here share it, is that the staff it's not that they're afraid, but they're getting close to that. And the way they can get in trouble is by not being tough enough. They don't want to be called out as leaving, money on the table, not going after the most draconian remedies that they can possibly get. And I've just had a matter like that where it was done without CIDs, civil investigative demands. It was on the basis of letters and that kind of thing. But it was like, we are under real pressure here, and if we don't wrap something up by the end of next week, the following things are likely to occur. Now, okay, fine, you can say that's standard operating procedure. But the level of concern and backed up by other stories that one hears from people who are dealing with the staff suggests that they're not happy campers in many cases, and they're really getting ground down to be as tough as possible, as quickly as possible, and oh, by the way, we're doubling your workload.
I mean, a lot of this, I think, came from now former Commissioner Chopra, or soon-to-be former Commissioner Chopra, who would issue these public screeds criticizing both his fellow commissioners, sometimes bureau management, and sometimes staff for not being tough enough. And he spoke frequently about the need to have both specific and general deterrence when FTC matters were resolved, so that the people who were the defendants or the respondents in these cases would clearly be, if not penniless, close to it, and others would see that, these kinds of actions do not pay. And he viewed the world in sort of very black and white terms, and, staff who sometimes has a little closer to the facts, sees the gray in things, and, sort of got chastised for not being tough enough, and, bureau directors and managers have lots of cases and they want to move cases, so they compromise to resolve cases so they can bring other cases. And if you want the last cent in every one of your cases, you're going to end up trying a lot of cases, and that has happened. And it's unfortunately it's often easier for staff to just say, well, no, we're just going to keep on going than to settle cases, which I don't think is a great way to run an enforcement agency. But it's and we'll have to see where Chair Khan is, but I mean, she worked with Chopra. He was clearly whispering in her ear, at least for the last couple of months, and I'm hoping that doesn't continue, but we'll see.
Rand?
Yeah, I mean, I think there's kind of two things at play here, and I have the same sense. Morale is not great with staff. I think first, there's this, belief, as I was saying earlier, that industry in general is bad, right? And a lot of the career people at the FTC are probably of a different mind. There are people who make mistakes and do bad things periodically, but they're not necessarily bad companies. Or there may be a few bad companies in the barrel, but you don't toss everybody into that category. And I think it just leaves a bad taste in their mouth. As Len was saying earlier, when commissioners won't meet with industry, and it's not really how they want to operate. And there was an article last week. There's two longtime, kind of fairly high up people leaving the FTC. Manish Mathal, who has run the privacy division forever, is going to Wilson Sonsini, and Daniel Kaufman, who was the acting bureau director, is leaving to actually come to our firm. And I've heard of at least one other senior person who's on the verge of accepting an offer at a different firm. So I think we're going to see some pretty high-profile departures, which is unusual. The FTC's had this period of a lot of stability. And then the other thing I hear is just micromanaging, where staff feels like everything they do has to go through this vetting process and very micromanaged. I had staff actually apologize to me the other day about how long it took them to circle back to me on something. which was a long time. But and they came out and said, this is not how we would do business. This is not how we want to do business, but it's out of our hands.
Another kind of rift that seems to be opening is the division between the right and the left on the commission might be becoming more visible, kind of mirroring the country in a way. Do you think this is happening? If so, what effect is it having on how they're dealing with companies out there, and how they're handling their business?
Yeah, you know, I think it's unfortunate. I think that is happening, and as you say, Tom, it may be as a reflection of society as a whole. Although I do like to say that the FTC brought the Supreme Court together 9-0, you know, which is hard to do. So, you know, kudos to them. But Maureen Olhausen, the former chair, wrote an article years ago that I sometimes cite where she talked about the bipartisanship of the FTC and how many of their decisions were, you know, consensus 5-0 decisions. And I think if you go back and look at the stats now, you know, sadly that's not the case. And where I think it's particularly hard is when you have this whipsaw, right? You have one administration come in, they go one direction. You know, Len was talking about how the FTC has, on the antitrust side, right, revoked prior guidance, which is not that old. We're not talking about guidance back from like
2 years old.
Yeah. And you know, and I was meeting with the Bureau the other week, and I cited something by two very respected former chairmen, Potofsky and Muris, a Democrat, Republican, and they were like, yeah, we don't care what they thought. And just this lack of concern about precedent and just changing the rules, you know, it leaves the industry in kind of at a loss, right? You can't rely, you can't have that same certainty. You know, it could all, and just the other day, the FTC on the antitrust side, they're going to look at a arrangement between JetBlue and American Airlines that the prior administration blessed. So if we start to reopen prior investigations and all that, it's not good.
You know, the commission is actually not a very large operation. I mean, it's got about 350 lawyers or so. For years, its budget was, well, one former chairman described it jokingly as a rounding error in the federal budget. And consequently, when you get that kind of division in a small agency that really works in a collegial way most of the time, it's a surprise, and it to the point where the staff doesn't really like coming to the office that much anymore. But there's sort of a right and left kind of that begins to approach it, but it's sort of there's the chair and her group that sees themselves as progressives, and then it's almost like the debate within the Democratic Party about you've got progressives and you've got moderates, because the Republican commissioners are not exactly flaming right-wing, they're basically traditionalists, and Chair Khan is very aggressively progressive. So, and it gets into occasionally, and actually, Len, if I can tell the story
Sure.
that you mentioned the other day, there was. Traditionally, there's a lot of sharing of information between the commissioners and the staff. And there is a story that one of the commissioners had to get in touch with a company that was the subject of a merger investigation in order to get a copy of the Hart-Scott second request that had been served on the company by the staff, because the chair's office had told the staff not to provide information to the Republican commissioners. That's a problem, and that's aside from that, it's sort of a reflection of a we-they rather than us kind of approach to the world.
Lynn?
I mean, that was atrocious. It blew back. There was, blowback from the Hill, and the chair last week said, "We'll make sure now that doesn't happen again." But she almost made it sound like it was accidental, and it was anything but accidental.
Right. Yeah, that's interesting. I mean, it's interesting perspective that the rift within the Democratic Party, it's almost like a new versus old. It's like we are going to come in and stomp in and do things our way. This is the way that things are going to be now, just completely blowing precedent out of the water. And that's always going to create an issue.
Yeah, I'm not even sure that they care that much about these departures, right? Let's get rid of the old folks.
Right,
We'll bring in, all the 35-year-olds.
Yeah, we'll just plop our people in their place, and yeah, that makes sense. Ed, I'm going to turn to you. Obviously the biggest Supreme Court decision of the year when it came to all this is AMG, which shelved the FTC's ability to use Section 13B of the FTC Act to pursue monetary penalties against bad actors it was regulating. What's the initial fallout, and how do you see the FTC reacting to this in the coming months?
Well, the AMG case decided 9-0 by the Supremes in April, essentially said that a provision of the Federal Trade Commission Act that gives the Federal Trade Commission the authority to go to court to get a permanent injunction in an appropriate matter does not imply that a federal judge can, on the request of the commission, order the defendant to provide redress, that is essentially refunds, for everybody that was affected by the bad acts of the defendant. What that means in a nutshell is that in the large majority of cases, when the FTC goes into court, all it can get is an injunction saying, sin no more. Now, there are two exceptions to that, and three really, and the commission is trying its level best to at least threaten people who are the subject of an investigation that they could get hit with one of these monetary exceptions to the rule. The first is that if you are violating one of the commission's rules, and there's a wide range of rules out there, ROSCA and the TSR and a bunch of others, and those of you who are in this particular industry know what these things are, you basically can get hit for a violation of Section 19, and I won't get into the deep weeds, but you can get hit with money if you're violating a commission rule. Secondly, they can do something which is extremely time-consuming, and that is bring an administrative proceeding before an administrative law judge, and after the ALJ issues a cease and desist order, then they go to federal court to establish that the conduct that he was the subject of the order was something that an ordinary person would know was dishonest or fraudulent. That takes forever and a day, okay? I mean, you've got appeals to the courts of appeal, et cetera. So, I mean, that can be a 5-year process, and it's not an effective threat because in addition to the threat to the defendant, it's going to tie up staff for forever. Right. And the third, and this is they're doing a little more, is what they get involved with as co-plaintiff with state attorneys general. And some of the state AGs are much more aggressive than others. New York, California, Illinois. I mean, I could go down the list of state AGs. And the state AGs do have the power to get monetary judgments. And the combination of the state AG, or a bunch of state AGs, and the Federal Trade Commission going after a company is just the worst. And it's not just the threat of money, it's that the state AGs sometimes don't coordinate, or sometimes one thinks purposely don't coordinate, so there's duplicative subpoenas from people, and you've got to return all these different, it's awful. So, you know, this is a horrible, it's bad for the commission, but if you fall into one of the categories that the commission has a strong incentive of at least suggesting that they could put you in, it can be very bad for you. And you know, Glynn has been following the question of what the Congress is going to do about it.
I mean, the FTC, before the Supreme Court ruled, was lobbying Congress to fix this, because I think they saw after oral argument it might not go their way, and it clearly didn't 9-0. So the House has passed a bill that would restore the FTC's lost authority. Some of us would say it would create that authority, and that bill would actually apply retroactively. So if you're in litigation with the FTC would regain the power that it had lost, regain the remedies that it lost. If you were to get sued tomorrow, it would apply retroactively. That bill has gone nowhere in the Senate, and it appears to be going nowhere in the Senate. Now, there are lots of talk about antitrust bills to target big tech, and it could get appended to that. It could get appended to something else. I mean, the 13B was created as part of the Trans-Alaskan Pipeline Act. It got sort of stuck on the back of that. And something similar could happen with this, but it does not seem to be going anywhere. The U.S. Chamber of Commerce has been pretty forceful in lobbying against it, and what they've been arguing is that Section 13B is just sort of too amorphous, and I think that the current overly aggressive chair is sort of feeding that a little bit, that Congress is, especially the Republicans in the Senate, are not anxious to give this very, very progressive chair this very amorphous tool. So I think actually her actions are probably counterproductive on the Hill. We'll see what happens, but I think that's the case.
Yeah, I mean, I think it, hopefully this doesn't end up being a situation of being careful what you wish for also, because, as Ed was saying, they're being much more aggressive in terms of trying to find violations of rules, and then the civil penalties can add up far more quickly than consumer redress. They already announced the ROSCA case that took a somewhat novel interpretation of ROSCA. We have two matters right now. One of them involves a very novel, creative interpretation of canned spam, which is another rule, and then something even more obscure, but a pretty novel interpretation of the eyeglass rule. So. And maybe the courts companies will fight this and the courts will beat some of it down, but if the commission starts aggressively expanding all these rules, we could actually end up in a worse situation. And then the other tactic we've started to see is saying we're gonna hold the CEO individually liable, which they have the right to do, but doing it again on a much broader basis. But then in settlement discussions saying, well, you could essentially buy your way out of that, right? Mm-hmm. If you could, even though I've yet to figure out the link between like paying money and the CEO being liable, like how those two are interconnected, but pretty much just saying, we could drop the CEO, but it would cost you more money on the settlement side. Mm-hmm. So,
I think that's called extortion. But
yeah.
You're talking about novel interpretations of existing rules. Len, I was going to ask you about the rulemaking processes. It seems like they're revving up in different ways, possibly to create new rules, different rules. Obviously, that takes time, 2 to 3 years out. We're looking, but have there been any immediate examples of that?
They haven't issued any new rules. What they have done, and this was started under acting Chair Slaughter, and the Chair Khan is now continuing it, is they've centralized all of the rulemaking in the Office of the General Counsel. Historically, to the extent that the FTC was engaged in rulemaking, the Bureau of Competition did its rules, and then the Bureau of Consumer Protection, and even the different parts of the Bureau of Consumer Protection would do the rulemaking. Now it's been consolidated in the Office of General Counsel, and then Chair Khan has changed the FTC procedures for writing rules. And the FTC writes rules in two ways. Sometimes specific statutes give it a very efficient way to write rules, like the telemarketing sales rule that was part of the Telephone Consumer Protection Act. But the FTC's general authority to write rules comes out of the Magnuson-Moss Act, and it's kind of cumbersome. They have to prove that a practice is prevalent. They have to have hearings where there's the ability to cross-examine witnesses. So that takes time. Historically, that was supposed to be done under FTC rules with a ALJ presiding over the proceeding, with staff then issuing a report, and all of that going to the commission, which would issue the final rules. Under the new expedited procedures, the chairman or her designee can be the presiding officer over the rulemaking, and staff doesn't have to issue a report, and there's no appeal to the commission. The commission just does the rulemaking itself. Much more centralized. Now, whether that makes it more efficient in the long run, we'll see, and whether they actually do it. I think in certain instances, The FTC is using the threat of rulemaking to try and move Congress to enact legislation. I think privacy is one area where they're saying, well, okay, if the Republicans in the Hill don't want to pass privacy legislation, we'll just have Lina Khan write some rules on it, and hoping that that will move some of the Republicans. So far, that hasn't worked, but I think you'll see that. You might see that on covenants not to compete for employers and a couple other areas where the FTC has threatened to write some rules.
Mm-hmm. Yeah, and the other incentive for them to do rulemaking is, as I mentioned previously, one of the ways that you can get money is if you can prove that someone violated a rule. Yep. And that is explicitly provided for in the FTC Act in Section 19. So the more rules you have that are fairly sweeping, the broader the threat of monetary. And frankly, the bigger hammer the staff has in trying to negotiate a settlement.
Tom, one other point. We don't know yet exactly what rules they're going to write. But this group ought to keep its ears open. They ought to be listening, because if there are rulemakings, the industry ought to think about participating, depending on what they are. Mm-hmm. Because if you just let the chair, pick what evidence gets presented, you can assume the rule. And the better the record is before the administrative agency, the better chance ultimately you would have of challenging that rule if it's unfavorable in court. So I don't have an ask yet. Tom doesn't have an ask yet, but I think this organization and other trade organizations for people who are in marketing, who are often in the FTC's crosshairs, need to pay close attention and need to be prepared to act quickly, given what some of these rules could be and how, at least in my view, I think they'll probably be fairly draconian. I don't think they're going to be writing rules that are favorable to industry anytime soon.
Right. There is, let me just toss out one thought, and that is, and this is sort of related but collateral. We've been talking for about half an hour. There was, we mentioned that Commissioner Chopra, who was part of the 3-commissioner Democratic majority on the commission, has just been confirmed as head of the Consumer Financial Protection Bureau. He is therefore leaving. So the commission is going to have a 2-2 Democratic-Republican tie. They have nominated, or in the process of nominating, a new commissioner who's a professor at Georgetown Law School, a privacy expert, fairly well thought of, but frankly, given what's going on Capitol Hill these days, and don't need to get into the details. I mean, everybody is focused on all these big issues. To actually have the time to do a hearing and actually schedule a confirmation for a new commissioner may not be on the highest rung of priorities. So it could be that the chair is going to be stuck with a 2-2 majority for a while, which will be a very uncomfortable position given all of the stuff that we've been talking about, which sort of assumes that she's going to be able to have her way on a 3-2 basis.
And I mean, it's interesting. Commissioner Chopra has been confirmed, but he hasn't left yet, and which is noteworthy. I mean, normally you would have assumed the next day he would be in the CFPB. I'm assuming that's because they're trying to figure out how soon Bedoya, who will be the new commissioner, can get confirmed. But at some point, you have to assume he's going to leave. Chopra will be leaving for the CFPB.
Yeah, I mean, I think the other tool that certainly you're going to hear Commissioner Chopra's name a lot up here, but that Commissioner Chopra has advocated in addition to rulemaking is the FTC has this somewhat obscure authority to send, if they've litigated and won a case, they can send out notice of that. They can send out the decision to everybody, right, and put them on notice about this order, and if you violate the order, they can get penalties. Now, the order has to be, there has to be a relationship, but that's kind of ill-defined how close the conduct has to be to the subject matter of the order. And Commissioner Chopra wrote an article a little while back advocating that the FTC much more aggressively use that authority, again, to get money to circumvent the Supreme Court decision. So
it's an amazing authority. In other words, if the FTC gets an order against Ed, it says Ed can't sell subscriptions without making this disclosure. And Randy is now aware of that. They can go after civil penalties against Randy for violating Ed's order. It's pretty remarkable. I mean, I don't think they've ever done it.
I've seen. I think they've sent out notice once or twice, but I don't know that they've ever
done it.
gotten money. Yeah.
It's a tough hurdle, and
Yeah.
the fact that it's Commissioner Chopra, he's not a lawyer, and thinks this is a good idea. I don't think he understands how hard it would be to do. But if you get in the middle of this, you still have to defend it, and so I think it gives you part of the idea that they're looking under every pillow for tools to go after industry.
From the staff's perspective, the fact that it is Commissioner Chopra who is leaving is something which causes the staff to do a happy dance every day. He is not well liked at the FTC.
He's despised.
In fact, he's despised.
It seems, I mean, I've been covering this for 20 years, and we've heard time and again, oh, well, what if they can lump the media agency into this, or they can lump the payment processor into this. They're actually making that move in an attempt to actually try to make that happen. Marketers' risk tolerance, where should it be right now? I mean, it seems like there's a lot of big flashing red lights here that they should be on high alert. Is that the case, Randy? I'll ask you first.
Yeah, I mean, notwithstanding my earlier comment about there may be more focus on the big brands. Right, if you get in trouble, right, if you're a small marketer and the eye of Sauron, right, the FTC focuses on you, I would expect no mercy. Mm-hmm. And so it's not a good time, I think, to push the envelope. We've got so many different cases. I have a case involving, reminds me of, I think, Ed, you did the Steve Garvey case many years ago. I have a kind of a very well-meaning endorser who's now in the crosshairs, and there isn't this. I feel like in the past there was this sense of prosecutorial discretion. We're not, yes, you did something wrong, but we get it, or we understand, or we're going to have mercy on you for whatever reason. I don't have that vibe of mercy anymore.
Well, and it's not even just mercy; it's just sort of sense. I mean, we have clients who want to settle, and we have clients who want to settle and we're willing to pay a decent amount of money, and staff is almost paralyzed with a fear of being criticized, so that if you are investigated and they think that you've done something wrong, being able to resolve it quickly and efficiently and in a sensible manner is incredibly difficult. And we're expensive friends if you get in the middle of an FTC matter. And that part of it really sucks. I mean, we have clients who want to settle, and it's really hard to do so.
Yeah.
Let me toss out one other thing, though. I mean, the core issue with most FTC investigations is the very simple, what are you saying about the goods or the product? What have you got to back up the truth or substantiation of what you're claiming? That's going to continue to be the core of an FTC investigation. Mm-hmm. I do think, however, and this gets into the dark
patterns
thing, if the real sort of special sauce in terms of the FTC looking is if there is something in the way that you sell the product which calls into question obtaining confidential information from somebody, or making it very difficult for somebody to cancel. Or once you're in the website, it's impossible to get out of the website, mm-hmm. or things like that basically have to do with a little, as they say in New Orleans, a lagniappe of social media maybe, or that sort of thing. That is the thing that is really going to attract the attention, certainly of the chair and of her group, and therefore of the staff. Mm-hmm. It's not just a question of, are you making a, treats and prevents COVID-19, which, anybody can see is going to get them down on you like a ton of bricks. But the way that you go about setting up your sales procedure, the procedure by which you take payment, the procedure by which you share information with other sellers who might be interested in selling a related product. Those are the kinds of things that, given the interest of the chair, provides that little additional incentive to make sure, let's get those guys.
Mm-hmm. Mm-hmm. Makes sense. since you brought it up earlier, Len, and then you just mentioned it again, dark patterns. Can you fill in the crowd on that? I mean, I've heard the term, got a little bit of a clarification on it in a conversation last week, but can you share a little bit about that?
I wish I could share more. Justice Stewart in deciding a pornography case said, I know it when I see it. And I think that's sort of the FTC's view on dark patterns. These are disclosures on websites that would appear to be clear and would appear to be conspicuous and would, at least at first glance, appear to require some affirmative consent from the consumer. But for one reason or another, the FTC, maybe it's because even though the disclosures appear clear, there's still a lot of people who claim, I didn't sign up for this, or there's chargebacks, or after the fact saying, well, the consumer must have been deceived or manipulated, there was something covert here, and the disclosure's over here, and it should be over here. And the problem is it's very subjective, and I don't know if they're going to do a rulemaking. They've done a workshop, but in a context of a case at another agency where this word has now come up, we're like, the FTC blessed a set of disclosures, and now the CFPB is saying, well, I'm not sure those are good enough, and they're sort of mouthing these dark pattern things, and you can have lawyers view it and say, yeah, it's right next to the checkbox, it looks okay to us. But if you get a bunch of consumers to say, I didn't see it, they're going to say, well, you're obviously manipulating them, and you distracted them, and it's at the end of a long order chain. And so what I think it is, it's a tool to sort of second guess businesses if they can find enough consumers who complain. And it's just, as someone who counsels people on this, very, very gray as to where those lines are. And I think it's a real opportunity for the commission to do mischief.
It's like they're fishing out there, and
it is because we say it is.
Yeah, Ed, you had something to add there?
No, I think I'm quite cynical about it. I mean, I think Len laid it out, but I think to the extent that they have the opportunity to put in a complaint and mention that some of the dirty sales work was done through Facebook or something, this is like, Christmas comes early this year.
Yeah.
So I think that kind of misuse of the electronic, various electronic tools, it adds that extra thing. One other, just very quick, one of the interesting things about advertising law is, we're here talking about the FTC. But, anytime you are counseling a client, clearly you have the FTC in mind as the major reviewer, but you've also got the National Advertising Division of the Council of Better Business Bureaus, you've got class actions, and you've got competitors. And so when thinking about kind of how this all plays out, the level of threat that you perceive in any particular circumstance is going to depend an awful lot on, what kind of product is being sold to what kind of consumer, who else in the marketplace is selling competing products, and that kind of thing. So, I mean, we, quite rightly focus on the FTC, but one of the interesting things that's going to play out is when we've talked a little bit about state AGs, which are another kind of bear in the forest that, may show up and cause unpleasantness for your client. And now that there is a deeper relationship between the states and the FTC, that's something else to keep in mind. So as we look down the road, we're going to be seeing perhaps a sort of a feedback loop with this new FTC in ways that we don't fully appreciate, having an effect on class actions or having an effect on competitor actions under the Lanham Act.
Right.
Just to go back on my dark pattern soapbox here for a quick second, I think to me the most shocking thing that came out of the workshop is there were several people that testified, right? You book an airline ticket, and before you can pay and so forth, that you can buy travel insurance, right? And you click no, and sometimes you get a pop up. So you don't want to protect. You want to put your trip at risk. What a horrible person you are, right? And so that was given as an example of a dark pattern, right? You're trying to manipulate people into making a choice that they might not otherwise have made. And I heard that, and I was like, well,
that's what we all do here, right? That's what everybody here does.
And so I think the commission, if they're really going to go down this path, they owe an explanation to industry. Okay, where are they going to draw that line between advertising that's lawful versus not. I mean, today, literally, I had a class action plan. I almost fell over. A class action plaintiff's lawyer emailed me about dark patterns, and his comment was, well, isn't this what they call marketing? So the fact that he got that just stunned me.
It's funny. It's the name is like, let's make it spooky. It's
right.
it's like a hot new spin-off of Stranger Things.
It is
Dark
October.
Patterns, right?
October, after all.
Yeah. One last question from me, Randy. I'll start with you. If you can select one thing for the attendees to take away from today's conversation, what would it be?
We've talked about it a little bit up here. I would say watch the Consumer Financial Protection Bureau, right? They kind of went to sleep during the Trump administration. Rohit Chopra, who we've also mentioned many times, is going to take over there. People have all, they have the same, in some ways, broader authority because they have this abusive practices provision, which no one quite understands. They're not limited by the Supreme Court's AMG decision. And people have always speculated, gee, they have jurisdiction over financial services. Maybe virtually everything you do in some way touches financial services. So I would watch for Rohit Chopra, and he's a one-person show there. He doesn't have to answer to a commission.
Or to Congress, which
Yeah, so he'll have to answer if we have a new president in 3 years. That's the only impediment, right? So I would keep an eye on the CFPB.
Ed?
Well, we're here at a very interesting time, of course, right at the beginning of a new FTC administration, and we're speculating. I think that one of the thing to watch is the money. It's the old Watergate, follow the money. What I think we all have a sense that if Chair Khan was writing her own ticket, she would be focused more on antitrust investigations of the big media companies. And she's got these other things she needs to do too. The question is, are we going to see the Bureau of Consumer Protection raided for servicing the antitrust needs of the commission, et cetera? Is the commission going to get a lot more money? I mean, I don't know if everybody's aware of this, but the House of Representatives has passed a bill that would set up $1 billion for a privacy bureau at the Federal Trade Commission. That is, going nowhere in the Senate. But there is going to be a big focus on privacy at the commission, and that may be at the expense of more traditional advertising enforcement. What are you saying? What have you got to back up what you're saying? As I say, it's going to be one of these things where between privacy and dark patterns and other things, the cases that are going to be brought are the ones that are advertising plus, in my opinion.
I think that's right. I think the other thing that you'll see is, to the extent, and this is true generally, but I think it's going to be especially true now, to the extent that the FTC thinks you're preying on disadvantaged consumers, I think that's going to be even more aggressively enforced here. And to the extent that you're tracking people, behavioral advertising or using biometrics or using anything to market differently to certain classes of people, I think that's going to be a real hot button. Professor Bedoya has written about this a lot. It's a passion of his. He's going to push the agency to do more there. And so, again, no one knows exactly what the rules are, but they will use their unfairness authority broadly, I think, to go after those types of things.
Makes sense. Last couple minutes here. Have any questions from the audience today for our panel? It's kind of hard to see, but it doesn't look like I'm seeing any hands raised. Anything? Anyone? You guys covered it, obviously. It's all good. Maybe they're scared by dark patterns. Maybe that could be it. Well, thank you guys. Again, appreciate you being here. Thank you all for joining us today. And we will return to the stage at 3 o'clock with our research partners, DR Metrics and Kantar Media, presenting their latest and greatest industry insights. That's our last session of the day today. And then, of course, tonight at 5:30, we get to drink again together outside at the Float Pool Club for Drinks on the Deck, which is presented by Locke and Wexler. So we hope to see you either at 3 or at 5:30.
And you'll have the Yankee game on out there, right?
I am going to be lobbying with the bar to get that game on, absolutely. Thanks.